right?
No, I was actually bringing the document. I was basically a courier.
Okay, but was the document being executed by the bank or the trustee? Who was executing the document?
The trustee.
I
had reassigned the trustee.
And who was the trustee?
Just so happens it's my father right now.
Yeah, just some dude's name. They're not used to seeing that. Okay? So, not that they shouldn't have filed it. They filed the substitution of trustee.
Yeah.
Yeah. Okay. So, that's why getting the POA of the trustee, where you can execute the document as the trustee, and then you just mail it into the county, because that's probably how the trustees do it.
They actually use, like a legal courier service.
Okay. So you use a legal courier service.
I did. And that's when this guy was like, he shows up to do this, and he goes, they wouldn't do it. I mean, this guy was he was kind of, I shouldn't say didn't have backbone, but he's like, well, he didn't understand what I was asking him to do, because it was clearly out of the ordinary. I might be the first person in Minnesota to ever do this, you know? And
so how do you know that the trustees typically use this guy?
I don't.
Exactly. So why don't you just mail it into the county like a trustee would, from the trustee? See, the thing is, and you said you filed a whole bunch of other stuff on the property?
Yeah.
The process. They're looking at the title on your house going, oh, there's some crazy shit going on in this property.
Oh, it's
That's
awesome.
why they refused it. That's why I'm saying keep your stuff private. You start filing all this crazy stuff into the county on your property that doesn't look like it should be there. It doesn't have their form. You're hurting yourself. Because let's say you want to sell the property down the line, you aren't going to get title insurance with all those crazy filings on there. It needs to look like everyone else who's cleared their account. Reconvey, and if, now let's go back. Because let's say you don't have the time to do a process with the trustee, to get the trustee to grant you a specific power of attorney, to execute the reconveyance and the notice of rescission, but you've already established that you have a specific power of attorney for the bank. What can the bank do? Substitute the trustee. So then you could do a substitution of trustee. Don't use the homeowner name as the new trustee, okay?
It's better to use a trust or some kind of bank.
Or a company with the name trustee in it. Right? Or DBA. Go file a DBA with the county. Mike Smith doing business as All American Trustees Company. Right? Okay. So, and then once we've done this, now we execute the documents. We execute the notice of rescission if the property is in default or has had a trustee sale, and we execute the full reconveyance of deed. What have we done now? Perfected our title. So now we've settled the account and we've perfected the title. Now, if you've lost possession, now you're going to go about gaining possession of the property. If you're in possession of the property, do you need to do anything about the possession? No, you're in possession. But you need to be mindful of these processes and administrative process in general. This is not for beginners, this process. You need to do a lot of studying to do these processes, because what if they continue to move forward with the foreclosure anyways? You better rebut any presumptions and respond to every step of their process. If you continue to get statements of account, what happens if you hold on to a statement of account for 30 days? Validation of debt. Okay? So be mindful that anything you receive in relation to the account or the title, foreclosure, anything that comes in after you've perfected the account and the title, you better respond. And it better be a meaningful response that rebuts any presumptions that their process is making. Okay? So if you've lost possession and you've settled the account and perfected the title, well, now you're going to give the bank a notice to vacate. 3-day notice. Where are you going to send the notice to vacate to? Nope. You guys, this is a public process. Nope.
Trustee.
Nope. What's that? You can post it on the property, that's one, but is that sufficient notice?
No.
Who are you going to mail it to?
The person with the entrance, with the secured entrance. Who bought the house?
No. If somebody's in the house, you guys don't do this. If they've actually sold it to a family and they're living there, I mean, come on, really? Do another process to regain your loss, okay? But don't go kicking regular people out of their house. I'm saying if the bank sold it to themselves and the property's abandoned, do this. If you guys go around kicking people out of their houses, you're no better than any of the banks. It's not very compassionate. Not to say you don't have a right to, but what you could do is give them notice that they're going to be paying rent to you. Right? So, if they're in fact, because sometimes the bank will rent the property. Right? So you got to establish, look at the title, if it's already gone through trustee sale, see what the latest title documents on that property are. Because if the bank is still the registered owner, then they're either renting it or it's abandoned. Okay? My notice to vacate, my 3-day notice, needs to go to the public side of the corporation. Nobody here knows how to serve the public side of the corporation? What? How do you serve it? How do you serve a corporation?
There's an agent registered with the state.
Ah, Gordon knows. Registered agent. Agent of service, it's also known as. If you go to the Secretary of State records for that corporation, it's going to show you a special name and address of the registered agent or the agent of service.
That's the person who accepts service and is every corporation has to have an agent to accept service in that state.
Okay? So that's where you're going to send your notice to vacate. And I would also go pin it to the door.
That's if the corporation owns it.
That's if the corporation owns it. Yeah,
Yes.
Don't kick families out of the
Just
home.
like every corporation, yes.
Okay.
If the bank took it back, the bank is a corporation.
What's that?
If the bank took it back to themselves, sold it to themselves,
Yeah.
they are a corporation.
Exactly. They are. Okay, so step 2, after the 3-day notice goes in, and you've waited at least 3 days, 3 days beyond their delivery of it, you want to give them sufficient time to respond, but they only have 72 hours to respond. Then you go file an unlawful detainer, or a complaint for unlawful detainer. There's 2 things you must have. 2 witnesses you must bring with you to your unlawful detainer case. What I suggest is go watch a couple of them. There's plenty going on right now. You can sit there for 8 hours in court and watch unlawful detainer after unlawful detainer after unlawful detainer. Go to the court, ask them which department of the unlawful detainer is being held in. And go sit there and watch. Because every attorney does it the same. There's 2 witnesses. One witness is going to say, and what I would do is write down the questions that the attorney asks his witnesses. Write down the process that the attorney does, and then mimic it. Good afternoon, Your Honor. So-and-so here for the plaintiff. Unlawful detainer on Bank of America. I've got my witnesses. And then you bring your witness up, and you ask the same questions an attorney would ask. On such and such a date, did you serve the 3-day notice? Yes, you did. Yes, I did. How did you serve it? I mailed it to the agent of service. Do you have a record of that? Yes, I do, Your Honor. I'd like to present evidence of the record of service. How else did you serve it? I pinned it on the door. And at what date did you do that? On such and such a date. Your Honor, evidence of service on the door. Then I bring my second witness up. Did you serve the summons for complaint of unlawful detainer? Yes, I did. On which date did you do that? On this date. Your Honor, I'd like to submit into evidence. Actually, that'll already be in evidence because the proof of service must be filed with your unlawful detainer complaint before the hearing. So your proof of service on the unlawful detainer will already be in the case, but you still bring your witness to say, yep, I served the unlawful detainer.
If I have a girl witness, does she have to go, and yes, I did, Your Honor?
Absolutely. Okay, so then what's the judge going to do? He's going to go, bing, and guess what? People have done this. Guess how many times the bank has shown up to the unlawful detainer hearing? 0. So we get our summary judgment right there. Judge goes, okay, I find for the plaintiff. Then you get your writ of possession from the judge. What do you do with your writ of possession from the judge? You take it to the sheriff. You say, I'm kicking Bank of America out of my house. Or out of my house. And they go, you're kicking the bank out? And then they're thinking, I wonder if I could do that. And then a couple days later, 5 to 10 days later, sheriff comes back. Here's the keys to your new house. Thank you very much. And now I've got a settled account, a perfected title, and possession, and thus a perfected security interest. Okay? Now, I may also at that point file some other encumbrance to protect my interests so that it'll predate any and all other encumbrances that may be tried to file on this property. Even though I've already got one in the form of a grant deed, I may set up a new deed of trust. And I may assign a trustee. I'll assign myself as the beneficiary and grantor and appoint Gordon here as my trustee. Maybe not Gordon.
Trust me.
Okay? Seems simple enough? All righty. We're going to take, we have a couple more questions, then we're going to take a break.
Got a mic coming your way. And that was a good point you brought up, Jim, because individuals are not required to have an agent for service in the state. That's only for corporations.
Yes.
Gordon, recently I just went to a seminar where there's a new federal law that was just passed regarding mortgage foreclosures, which stipulated you have to honor lease agreements that's on record, or you have to at least give them a 90-day notice to vacate a property based upon a foreclosure process.
Right.
Is your process, you're going into the public side, therefore are you going to have to abide? I would assume you would abide
if
by
there's
that.
someone leasing the property.
Pardon?
If there's someone leasing the property.
Correct, right.
You're going to give them notice and you're going to be collecting the rent.
Right.
If anything in this process must be done in accordance with the statutes of your state. See, I've just given you what I know about California. I don't know how the 3-day notice unlawful detainer writ of possession process works in any other state.
Right, but there's
I just haven't had the time to do the research.
But there's a new federal law that covers all the states on that 90-day period.
Yeah, which is, in California, there was already a 60-day period.
Georgia's 90 days.
See, and Georgia already had a 90-day.
But you would want to be fair to any tenant anyway. 90 days
Yeah, if there's a tenant and they're leasing, you want to be fair. And actually, you may not want them to vacate. You may just say, hey, you're going to be paying rent to me in 60 days. Or after I've perfected the unlawful detainer. So you don't have to leave. This notice is for the bank. Right. So when I take possession, you're going to be paying rent to me.
Back to the perfecting the title. If someone's current on their mortgage, how would you do that then?
Say that again?
If someone's current on their mortgage, they're making their payments,
right,
and they're going to perfect the title, are they going to
Well, first they have to settle the